everyone, my name is Julia Fleming, and today I'll be talking about some trends we've been seeing in the class action employment context, as well as some compliance strategies we can implement to ensure we're reducing risk and exposure to what can be costly lawsuits. So first, just to set the scene a little bit about what are class actions. As opposed to lawsuits that are brought by one individual or one business, a lawsuit is brought by one class representative on behalf of a class of similarly situated individuals. In the employment context, these are typically current and former employees. And when bringing the lawsuit, there is a defined class of individuals. So on this screen, we have an example, which would include a class of all individuals who were employed by a certain restaurant in the city of Seattle who worked as line cooks during a certain period of time. And so in this lawsuit, the employer would be required to look through their employment records and identify any and all current and former individuals who would fit this definition. Now, to proceed as a class action, the lawsuit in the class itself must satisfy a number of requirements, which include numerosity as to how many potential class members we would have, commonality and typicality to look at the type of claims and whether there's similar traits between the class representative's claims and the class itself, those claims, as well as the adequacy of representation, looking to both whether the class representative and the counsel representing the class can fairly and adequately represent the entire class's interests. Now, there are some areas that may be more susceptible to class actions because the claim results from an action or a pattern or practice that affects a group of people in a similar way. So this can include wage and hour violations. For example, if we have an employee who believes their employer is in a certain city that requires a different minimum wage depending on the size of the company, they may believe their minimum wage rights have been violated and just similar to their other counterpart employees. This would also cover overtime claims if there's a policy or practice at a certain company that results in employees missing their meal or rest breaks. This could lend itself to a class action, as well as if employees are misclassified as independent contractors when they really should be classified as employees and therefore entitled to these minimum wage, these other legal protections. Now, one area that we've been seeing the most class actions brought in the context of is the Equal Pay and Opportunities Act. And this was enacted in 2018 and has a number of goals within it, one of which is the equal pay portion, which applies to employers of all size. And this provision of the EPOA prohibits employers from paying employees with similar jobs different wages based on their gender. Now, of course, employees can be paid different wages based on other factors such as their training or education or experience. Now, another provision in the EPOA relates to wage and salary history protections. This prohibits employers from asking certain questions in job applications or interviews about what employees were making at past jobs. And the area that we've been seeing the most class actions brought in relation to is a requirement in the EPOA that obligates employers to include certain information in job postings. This provision applies to employers with 15 or more employees, and job posting must include a wage scale or salary range along with a general description of benefits. Another area that is susceptible to class actions is employment discrimination. Again, this can take the form of a class action if there's a policy or practice that impacts a protected class of individuals, as well as reverse discrimination, which is also referred to as, or can be referenced as, anti-affirmative action cases. Now, these cases became popularized arose in the context of certain Supreme Court cases involving college admission decisions and whether they could use a candidate's diverse background as sort of a plus or minus factor. This applies in the corporate context when businesses are implementing diversity programs or initiatives and are looking at an applicant's background and showing favoritism or preference towards their diversity. Now, some problems that employers can face with class actions. Class actions can be expensive, just given the amount of claims and individuals that might be entitled to relief. They can be a burden on a company alone just to be able to spend the time and resources collecting employment records for so many employees. And this can result in pressure to settle early in class actions. Now, statutory damages are a form of damages that an individual can be entitled to, even if they have not suffered any harm. So in the context of the EPOA, individuals may be entitled to statutory damages of $5,000 plus their attorney's fees. And $5,000 itself may not be a significant burden to a company. However, if we're looking at a class action and this $5,000 is multiplied across 50 or 100 class members, this is where it can become crippling to companies. Now, as is true in other types of lawsuits, discovery can expose other violations. I've seen this firsthand when dealing with a class action that was brought on wage and hour violations, and then pursuant to discovery, the class representative's job application was produced. And in this job application, it requested the individual's salary history, and this lent itself to a second lawsuit or class action against the same company defendant brought by the same plaintiff. Now, these three last bullet points relate to a trend we've been seeing in class actions, especially in the context of the job posting requirement under the EPOA. Now, job postings are available to the public. So we've been seeing that it's easier to find class representatives to bring certain lawsuits through social media, as an individual can find a job posting online that may not include all the required information under the EPOA, and then engage what we can call cookie cutter litigation, which would be bringing the same lawsuit brought by the same class representative against a number of different company defendants. And we've been seeing this in King County, several lawsuits brought each day against different company defendants brought by the same individual plaintiff, just because it's easy to go online and see these job postings. And the EPOA is sort of lending itself to this sort of abuse, because the class actions can impose this weight against potential companies given the statutory damages. And there's some incentive for class representatives to bring these lawsuits because they're typically entitled to a separate settlement amount along with class counsel, who's typically awarded a percentage of the total recovery. What are some ways that we can minimize risk to class actions? Well, we can, of course, make sure we have HR fundamentals in place. This would include internal processes for dealing with complaints that are set forth in a handbook or policy which is made available to employees, ensuring employees are trained on how to report and what to look for when making a report. Employers should, of course, be welcome to complaints and make employees comfortable to speak up about any potential issues they may see. These fundamentals should also include reporting mechanisms and investigation processes, certain company individuals that employees may be pointed to directly to make their complaints. We just want to make sure that every claim is being treated seriously and investigated, as every allegation has potential to become a pattern or practice allegation, and a single claim can explode into a massive class action. So we just want to head these off early in the process. Another way to minimize risk to class actions is to implement an arbitration program and agreements. And through this way, an arbitration agreement can require employees to waive their right to bring a class action so that we're able to mitigate risk and just fracture what could be big class claims into manageable bite-sized pieces. And of course, we can make sure we have insurance coverage in place and also just take a step back to analyze what would the statistical evidence show? Are only men being promoted? Is only one group of individuals receiving training, or only one group of individuals being disciplined for certain conduct that other groups are not? Now, the Department of L&I also offers a number of free resources. One of these is an equal pay calculation tool, which involves an Excel spreadsheet that employers can download and input certain information to determine whether employees are being paid equally based on their jobs. L&I also offers free voluntary consultations in which a representative can sit down with an employer and review their policies and point out any potential risks to the company. Now, L&I notes that if issues or violations are identified, that no penalties or fines will be issued as long as there are no active EPOA complaints filed against the organization during the course of the consultation. However, the consultation does not guarantee that companies will not get in trouble for any violations. And of course, we have legal counsel to review policies and practices and encourage, especially with the EPOA, to have counsel review job applications and job postings, as well as to assist in drafting arbitration agreements.